I'm sure you know that there are civil suits that are involved here. They were not charged with simply being mistaken. A police officer, anybody, self-defense, which is available to anybody, all of us, specifically states that as long as you subjectively believed your life was in danger, and as long as a reasonable person under your circumstances would have so believed, it doesn't matter if you're mistaken in that belief. You're justified in responding with the force with which you are confronted.
Now, when we talk about justification, though, I think we should put a finer point on this. We probably wouldn't be talking about this as much if there were not so many shots fired in this case. Again, it appeared to be a case of panic shooting, almost.
You would think so, and that's why so much was made of the first shots. Because again, if we just step back and look at this objectively, you have police officers confronted with a situation, they believe their lives are in danger. Isnora, for example, testified when he looked in the car, he saw movement. I believe Oliver testified that he saw the people in the car putting their hands up. Once those first two shots are fired, and I think that had to be a pivotal focus for Judge Cooperman, then as the shots are ringing out, nobody knows where they're coming from. Then the pure and utter chaos comes into play. And so you're right. I think that those first shots were very important. The perception which precipitated those first shots has to have been a tremendous focus for the court.
There is a great deal of adrenaline in those situations. I know from my own background as a law enforcement officer, when adrenaline takes over, it's very hard to keep it from kicking into overdrive. Although it does, as Mayor Bloomberg said shortly after this, he found it unacceptable. He thought there were too many shots fired. He thought it was inexcusable that there were so many shots fired. But again, unless you're a police officer on the ground, you really don't know what it's like to be in a situation like that.
And I have to say, with all due respect to His Honor and to all of us who have pontificated about what we think is too much and too little, the beauty of our system is, and I can tell you, trying cases for over 20 years, it's really all about what comes from that witness stand under oath. That's where we really find out how a certain event unfolded. And it's part of our great system that's where it happens, and that I tell you, juries and judges, in my opinion, are able to discern what goes on outside from what goes on inside the courtroom, and they do limit it to what goes on inside the courtroom. You know something? During all of this time, for 2 years, we heard so much going back and forth about Mr. Bell and his friends, about the officers and his friends, and then as we sit and listen to the trial unfold, in many instances, it was quite different from what was reported. So what's too much, what's too little, it really depends on what the facts are.
And I think we also have to point out that acquittal does not necessarily mean off the hook. These officers are still going to be facing some departmental charges as well, or departmental investigation at least.
Absolutely. I mean, the next step from an administrative capacity is there'll be an investigation by the NYPD, and a decision will be made as to whether to bring them up on departmental charges. I suspect that decisions need to be made by these officers as to, whether they want to return. I mean, they're entitled to their jobs, having been acquitted, at least, preliminarily. But we know from prior experience with other officers, they made a decision that they would be viewed as pariahs and did not want to return.
We hate to do armchair quarterbacking here, but let's talk about the charges themselves. As you looked at this case, especially from the grand jury standpoint, when the grand jury came back with their decision, and the prosecutor, DA Richard Brown, came in with his decision to go forth with the charges against these officers, there were a lot of charges leveled. Was this case overcharged?
I wouldn't say it was overcharged. It's an 8-count indictment, the 3 final charges being the misdemeanor reckless endangerment. It's the theories that were pursued that I think played an important role in the verdict here. The manslaughter and the assault charges, for the most part, were charged as intentional crimes. It was charged and defended on both sides, in my view, as an all-or-nothing situation. When somebody claims justification, they're saying, I did it. I intended to do it, but my intent was justified based on the circumstances. So the reckless count, it's hard to reconcile that with the claims made at the trial and with the evidence presented.
It's either one or the other.
It is. And so reckless is failure to perceive a risk. How do you fail to perceive a risk when you're firing 50 shots into a windshield that doing so may cause death? This was not a reckless case. This was an intentional case, and therefore, to a great extent, it was an all or nothing case. Were the officers justified in their actions, or were they not? And again, against the backdrop of beyond a reasonable doubt. The court found, and we were talking before about the failure to identify themselves as police officers, whether that played a role. Well, what the court found was that if Mr. Guzman at that point stated, "I'm going to get a gun," then when Detective Isnora followed him back, it was with that in his mind, in a volatile situation where there had been drinking, where there had been a heated argument, and now proposed or prospective gunplay, that he followed them back to that car.
At the moment you hear gun, it turns from a surveillance operation into something else.
Absolutely, and it was more than a surveillance operation. I mean, again, from the tactical plan that was put forth, it's hard to tell exactly how much planning specifically was there, but it was an investigation for which action would be taken upon discovery of a crime. So alleged prostitution, there was alleged narcotics trafficking, and then you have thrown into that some drinking and potential gunplay. That thrown into the mix, apparently Judge Cooperman decided, irrespective of whether he identified himself or not, when he heard gun, and then the car started moving towards him, he was justified in discharging his weapon. And I think in that regard, Judge Cooperman did focus on those first shots.
Do you think that we would have come to this same conclusion had this gone to a jury trial? Because, I mean, juries are given specific instructions in terms of how to weigh a case, and it seems as though Judge Cooperman weighed it the same way a jury perhaps would have weighed the evidence here, because I think we both agree that the burden of proof on the prosecution was not met here.
Agreed. Look, Craig, I believe so strongly in my heart in the jury system. I believe that while jurors certainly bring their life's experiences into that room when they're selected during voir dire, once the trial starts, the importance of it bears down upon them, and they take their duty and responsibility very, very seriously. So I personally, I believe in the system. I believe in juries. I also believe that Arthur Cooperman was going to call this case as he saw it. And if these lawyers felt and made the call that the evidence that would be put before the jury would be deficient, that was the right way to go. But do I think a jury would have? I think a jury would have done their job as well, irrespective of the commotion outside.
Well, let's talk about the ultimate jurist in this case, Arthur Cooperman. Again, as we spoke earlier, and for those of you who are just joining us, this is James Kousouros. He's an attorney at law, and you've had some dealings with the judge as well. You characterized him as a straight shooter.
Absolutely, he is. As I said before, scrupulous in the discharge of his judicial duties. He is a no-nonsense judge. I think that, from my perspective, he's unaffected by things outside that people say may affect somebody else's opinion, perhaps why they went non-jury instead of jury. And that I know that he sat there and he listened very carefully, and he took this as seriously as you ever, as a citizen of this country, want it to be taken. And in that regard, yeah, he's as much a straight shooter as you're going to find.
You know, I want to go back to the prosecution for a moment here, and we spoke of this a little earlier as well. Again, the prosecution having a huge amount of burden to prove here. Trent Benefield, Joseph Guzman on the stand were not the best witnesses, even though they were actual victims in this. There was a lot of controversy surrounding their testimony. One of them is saying that he was drunk, wasn't drunk. This was a real problem for the prosecution. These folks, I mean these witnesses.